Well, welcome everybody to the inauguration of the John E. Schiller Chair in Legal Ethics at Indiana University Maurer School of Law. The inauguration of a chair is really a momentous celebration. One of the most important celebrations a university can have, because it celebrates excellence in a vital part of the university's mission, and that is in the creation of new knowledge through research. The first endowed professorships, which were in divinity, were created over 500 years ago at Oxford and Cambridge. Those chairs were sponsored by Margaret, Countess of Richmond and mother of Henry VII. In 1546, her grandson Henry VIII established the Regius professorships in 5 subjects, among them civil law, and later private individuals joined in providing chairs such as the Lucasian Chair of Mathematics, which Isaac Newton held beginning in 1669, and which has been held more recently by Stephen Hawking. No pressure. The tradition, in other words, of endowing chairs is very old, but the honor associated with an endowed chair has remained unchanged. At our school, endowed chairs and professorships are critical to our ongoing mission of teaching, research, and service. Those chairs allow us to recognize, to recruit, and to retain the very best and the most creative faculty possible. And that faculty is obviously the foundation of any success that a law school has. The men and women who hold endowed chairs and professorships conduct important and significant research, attract the best students to work with acknowledged leaders in their fields, and enhance Indiana University's reputation for excellence. Our tradition here is to inaugurate new endowed chairs with a lecture, and such a lecture is a special event on just every level. With us today are David Jacobs, who is the generous benefactor of the chair, and John E. Schiller, the lawyer in whose honor this chair is named. And I want to tell you a little bit about the two of them and how this came to be. I first met David in 2005 when the Jacobs family announced its historic gift to name the School of Music. And the Jacobs name has since become synonymous with that school and with the excellence that is the hallmark of a world-famous School of Music. And the Jacobs family gift has really assured that the beauty and the transcendence that the School of Music creates every day will continue at IU for generations to come. And that is a gift to the world. David became an immediate source of encouragement to me in any number of ways. And he has been a friend and advisor of a lot of people here at IU. But I am very lucky to count myself among them. And now we will have generations of students here at the Maurer School who will be beneficiaries of David's vision. And this vision for this chair arises out of his respect for really the rectitude and integrity of John Schiller. John is an accomplished lawyer whose clients benefit from his expansive mind and his deep commitment to service and to communication. He's the kind of lawyer who fights not only for his clients, but for the greater integrity of the legal system. John's work has been described as a 4-dimensional chess game in which he is keenly aware that every move he makes on behalf of a client affects all other aspects of his case. Clients appreciate his gift for empathic listening and for strategizing to achieve the best possible outcomes for everyone in a case. And David has said that to see John's mind work is truly a delight. In 2006, John represented David in a highly complex lawsuit. David was deeply impressed by John's integrity, his judgment, his professionalism, and his passionate belief in the legal system. John's personal and professional rectitude inspired David to make this tremendous gift. This chair not only pays tribute to John, but has wider repercussions that will continue to contribute to the esteem of the profession. And for that, we all thank you, David and John. What a wonderful, wonderful gift, and what a wonderful story that I'll be able, and future deans will be able to tell generations of students in the years to come. Well, I could not have a more delightful task than introducing Hana Bucksbaum, who will hold the John E. Schiller Chair in Legal Ethics at our law school. Like John, Hana embodies the highest ideals of professional rectitude. She came to the school in 1997 after practicing in New York and Frankfurt, and her expertise is in private international law and international litigation. She is a gifted teacher and mentor, and she is really a cornerstone of our community. What David said of John, I can say of Hana. It is a delight to watch her mind work. Her judgment and her wisdom and the trust reposed in her by our faculty are in evidence in everything that she does here at the law school. In her work as a faculty member, in working with students, and in working with her colleagues, and with me as Executive Associate Dean for Academic Affairs. Hana's lecture today is entitled Class Actions in the Global Economy. Please join me in welcoming the John E. Schiller Chair in Legal Ethics, Hana Bucksbaum.
Thank you. Lauren, thank you for that introduction, although that was a little bit of pressure. I will try to do it. In preparing for this event today, I have been thinking about my own education in professional and ethical values. In my case, that education began not at school, but at home. My parents were both lawyers. My dad still is, a law professor at UC Berkeley, and in his spare time acted as a criminal defense attorney for local political activists, including the 700-plus members of the free speech movement and later the students who were arrested following the affirmative action strikes in Berkeley. My mom was a partner at a large corporate law firm in San Francisco, where she worked primarily in banking and represented Wells Fargo, among other clients. Both shared the same commitment to the unique values of their profession, and in all of their work, in representing clients, in educating and mentoring attorneys, they served that commitment with the skill and integrity that characterized the best lawyering. I was lucky then to be able to learn at home something about the practices of excellent lawyers. I'm lucky now to be working at an institution that cares about giving every student that same advantage of a deep contextual understanding of our profession's values, not just in the narrow sense of the professional rules of responsibility, but in the broadest sense of the judgment and the dedication that lawyers bring to their roles. We aspire to have our students become lawyers like John Schiller, who, as David Jacobs recognized, embodies the habits and the practices of the best attorneys. One of the school's signal achievements in recent years, under Lauren's guidance, has been to translate that aspiration into our program of legal education. And so I am very grateful to Mr. Jacobs for recognizing not only the values that he saw in John's work, but that training students in those values should be a priority in legal education. Your support of the school's work to that end is deeply appreciated. It is truly an honor to be named the holder of this chair. In accepting that honor, I would like to recognize the support of my friends and colleagues, and most particularly of my husband, Ed Herman. He has been my partner in every step I have taken professionally, from law school forward, to my incalculable benefit. The development of the global economy, in the sense of interconnected markets for consumer products, for investment capital, for labor, has necessitated the development of global regulatory strategies. Such strategies depend on the ability of countries to work together in coordinating or harmonizing disparate national laws and in establishing cooperative enforcement mechanisms. With respect to the public enforcement of the laws governing economic conduct, that project has been largely successful. In various areas, harmonized rules have been developed, creating common standards for the conduct of multinational business enterprises. Regulatory agencies, such as securities commissions and antitrust authorities, work regularly with their counterparts in other countries and also participate in multilateral organizations created to facilitate a shared approach to cross-border problems. With respect to the private enforcement of regulatory law, however, an entirely different picture emerges. Here, until relatively recently, we have seen the United States standing virtually alone in its commitment to ordinary civil litigation as an instrument of regulation and in its support of the procedural devices required to incentivize that litigation. Far from finding cooperation and coordination, we find constant friction between the United States and other countries. One of the most critical flashpoints for this friction today is the class action. Many countries are currently considering the adoption of new procedures for aggregate litigation, either across substantive areas of law or in connection with some specific regulation, like a consumer protection law or an antitrust statute. Here, the United States' historical and current practice with class actions clearly presents a rich resource of information and experience. Whatever one thinks about the successes and the failures of our class action system, and there are clearly both, it has been in operation for many decades. The procedural rules that govern class actions, the funding models such as contingency fee arrangements or fee-shifting arrangements that we have developed to encourage class litigation, the long history of refinements and adjustments that have been made to the system when it was perceived as functioning poorly, all of this is tremendously useful to other systems considering how to create a local model of group litigation. Yet, while some effort is being made to examine the United States as a source of information in this sense, the attitude that is emerging in many countries is one of antagonism toward our class action system. This antagonistic attitude runs particularly deep right now in the relationship between the European Union and the United States, and I will focus my comments on that relationship. European countries have long permitted certain types of collective litigation. One type common to many systems, for instance, is litigation by consumer or trade associations that seeks merely injunctive relief on behalf of the association's members. What European systems have historically not permitted, however, are class actions for monetary damages in the way we use them. True representative litigation in which one plaintiff can act for and bind the rest of the class members. Today, though, the adoption of some variety of that kind of mechanism is being actively considered throughout Europe. The tone of the public debate can fairly be described as hostile to the U.S. model. European regulators have characterized the procedural elements supporting U.S. class actions as a toxic cocktail. They have warned of the boogeyman of U.S.-style excesses, and they have invoked the specter of a litigation culture that benefits only lawyers and no one else. The former EU competition commissioner, in an effort to assure listeners that she was not supporting a US-style system, told an audience that she was leaving her cowboy hat at home. It was during the previous administration. I would like to talk first about why this antagonistic attitude has developed, and I will suggest that the United States bears at least part of the blame for that. Then I will talk about why we should care, about why this kind of antagonistic posture, about what this kind of antagonistic posture means for the future of global regulation. So why the antagonism? Part of the explanation lies, I think, in the way in which procedural reform is being driven forward in these countries. The motivation for that reform in Europe comes primarily from above, from the European Union level. EU regulatory law today covers a very expansive geographic territory and applies to a greatly increased level of cross-border trade. At the same time, European regulators face mounting funding deficiencies and coordination issues. And all of these are reasons to consider stronger private enforcement mechanisms to complement the existing public enforcement structure. And indeed, the European Commission has been pushing very hard for stronger private enforcement. Hence the interest in class actions for monetary damages, which make it economically feasible for plaintiffs to bring claims under regulatory laws, particularly those in which a large number of plaintiffs have suffered small amounts of harm. So class actions from the European regulatory perspective simply promise to increase the level of private enforcement in a way that will help them offset weaknesses in their public regulatory system. But while the motivation to introduce such mechanisms lies primarily at the European Union level, the actual changes that will be required must be made within the individual member states, because they consist of reforms to the procedural rules of national legal systems. Most European countries are not enthusiastic about these reforms because they represent very fundamental changes in their civil justice systems. In these countries, as one commentator put it, the fundamental model of litigation is still that of individuals pursuing the protection of individual rights against other individuals, because in their view, only individuals are vested with a right of action for the protection of their own substantive rights. So the core expectation in these systems remains that each individual must guide the disposition of his own particular claim, making true representative litigation, where one lead plaintiff makes decisions for all members of the class, impossible. It certainly makes the opt-out model used in the United States, in which a plaintiff might be part of a defined class without even realizing it, and might therefore not know that its claim is being disposed of, let alone participate in the disposition of its claim, also impossible. So, although there might be a benefit to class action systems in the form of enhanced regulation within Europe, adopting those systems would be tremendously disruptive to the culture of civil justice systems at the national level. Indeed, many European nations resisted immediately the changes proposed by EU regulators. The narrative that emerged for that resistance was a narrative of opposition to the United States model. This is a very powerful narrative because it draws on fears about vexatious filings, unprincipled attorneys, and the like. And once it emerged, the European regulators had to deal with it, primarily by casting any proposed changes they wanted to make as explicitly not on the US model, thus their increasing references to avoiding the excesses of the US system. So in this sense, the hostile attitude to the US class action model had more to do with politics within the European Union than with any relationship to the United States. Other explanations for the antagonistic attitude toward the U.S. class action, though, are found in the behavior of U.S. actors in exporting our system to Europe. One way in which this has occurred is through cross-border litigation in which our courts have opened participation in class actions brought under American regulatory law to foreign plaintiffs. For instance, in cases arising out of the activities of global price-fixing cartels, U.S. courts have certified classes that include not only U.S. purchasers who bought price-fixed goods in the United States, but also foreign purchasers who brought price-fixed goods in foreign markets. Similarly, in cases arising out of securities fraud, U.S. courts have certified classes that included not only U.S. investors who transacted in U.S. exchanges, but also foreign investors who bought their securities on foreign securities exchanges. In these cases, importantly, the claims of the entire class are decided under American regulatory law. And so the class action has been used as a vehicle for applying American law to conduct and transactions that are really very closely tied to other countries. The concern here is that U.S. courts in this manner preempt foreign procedural and substantive norms, overstepping their bounds by overriding other countries' regulatory choices. And that trend is part of the backdrop against which some of the animosity toward U.S. class actions must be viewed. The second U.S.-based factor in the development of this antagonistic attitude is the export of certain lawyering practices in the form of expansion into Europe of plaintiffs' law firms. Starting in the late 1990s, large American plaintiffs' firms began setting up offices in Europe. And the primary occupation of the lawyers there was to cultivate local claimants that could then be funneled into the big American class actions. Here, European countries felt that a set of professional practices were being brought to their shores with which they really disagreed. Throughout most of Europe, the funding models that we permit, the funding models that support class actions, are viewed as unethical and contrary to public policy. In most European nations, the default fee rule is loser pays. So a group of plaintiffs that brought an action against a defendant and then lost would be responsible not only for their own lawyers' fees, but for the other side's fees as well. Moreover, pure contingency fee arrangements are not permitted. So each individual plaintiff has to bear its own share of the lawyer's costs, which cannot simply be paid out of an eventual settlement or judgment. In our funding model, by contrast, the default rule is that each party bears its own costs. Moreover, plaintiffs' attorneys can recover their fees in the form of a contingency payment. And in class actions, the common fund doctrine maintains that attorneys' fees for the entire plaintiff class can be paid out of a settlement or judgment rather than borne on a more traditional contract fee basis by the representative plaintiff. So our fee structure, of course, enables class actions because on a traditional fee arrangement, class actions in which the claim of each individual plaintiff is small would not be sustainable because no potential representative would agree to bear the related costs, let alone the potential costs of the defendant if the class action turned out to be unsuccessful. But on the European view, our system appears to invert completely the attorney-client relationship, such that it is the attorney, rather than the class members, who makes decisions about the legal claims, and often who receives the only substantial compensation from a settlement or a judgment. So countries not eager to embrace such a system were dismayed when U.S. firms opened up shop in order to serve local clients under these practices. And And that situation was not helped by some of the most publicized wrongdoing of American plaintiffs' firms that emerged, including the revelation that one of our biggest securities firms had paid plaintiffs to serve as investors in securities litigation. So, to some extent, the imposition of class action values upon European countries by U.S. courts, including European claimants in regulatory actions, and by U.S. lawyers in establishing practices there, contributed to the climate of antagonism toward our system. Now, having recognized the manifestation of this antagonistic climate and some of its sources, we turn to the next question, which is whether it matters. We might be indifferent to the climate in which Europeans undertake procedural reform. Whether it's one of conflict or not, European states will continue with the reform process and adopt whatever form of group litigation works for them. But in my view, the climate does matter for three principal reasons. First, there really are valuable lessons to be learned from the U.S. experience with class actions. And those lessons do not lie in the generalities of our system, in the fact that we use class actions, or in a rough understanding of how class action attorneys operate. Rather, they lie in the specifics of how, over time, that system has been implemented and how it has evolved through efforts to address precisely the harms that worry current European reformers. Adjustments to our system have included the adoption of new procedural rules, enhancing the court's managerial role in reviewing and approving settlement proposals, the adoption of other rules slowing down the class certification process, which had been criticized as insufficiently rigorous and thus too plaintiff-friendly. Rules restructured the framework within which courts consider the appointment of class counsel and enhanced the court's control over the award of attorney's fees. In specific substantive areas, too, procedures were adopted to minimize the risks posed by class actions. In an amendment to our securities laws, for example, a new process was put in place to select the lead plaintiff in securities class actions in a way that was intended to strengthen the role of the client as opposed to that of the attorney in managing that kind of litigation. And, of course, the Class Action Fairness Act of 2005 brought more sweeping changes by shifting a large proportion of class actions out of state courts and into federal ones in order to stem perceived abuse of class litigation. Finally, in addition to all of these legislative and rule changes, many judicial decisions over the years on issues like standing or pleading requirements or standards for summary judgment have sought to fine-tune the balance between plaintiffs' ability to bring class actions and the need to protect defendants from non-meritorious litigation. Now, I raise all of this history not to say that the United States has arrived at the point of perfect design for class litigation, because I don't know if there is perfect design, but we haven't gotten there. I raise it to say that if one were trying to learn from the U.S. experience, this is where attention should be. And a climate of hostility toward the U.S. system gets in the way of this kind of analysis. If it becomes acceptable to say, as one European commentator recently did, that all you need to know about how bad the U.S. system is what you see in the movie The Runaway Jury, then the likelihood of learning anything meaningful is very, very low. Second, as the antagonistic attitude is expressed in other countries, particularly by courts and regulators, it generates a response. And that response may take the form of a retreat from conflict, which paradoxically may diminish the effectiveness of cross-border regulation. In my view, this is what is now happening in the United States. In recent decisions, our Supreme Court has recognized other countries' disapproval of various aspects of our system. In a securities decision issued last year, for instance, the court noted that, like the United States, foreign countries regulate their domestic securities exchanges and securities transactions occurring within their territorial jurisdiction, and the regulation of other countries often differs from ours as to what constitutes fraud, what damages are recoverable, what discovery is available in litigation, what individual actions may be joined in a single suit, what attorney's fees are recoverable, and many other matters. The court then went on to note that amicus briefs had been filed by a number of foreign governments, including Australia, the UK, and France, and that those briefs complained of the interference with foreign securities regulation that our court's application of securities law in these global class actions would produce. On that basis, the court concluded, the United States should focus on its own regulatory interest by applying its laws only to transactions taking place within its own securities markets in order to avoid engendering this kind of conflict and animosity. In a similar case in the antitrust area, the Supreme Court stated that Congress might have hoped that America's antitrust laws, so fundamental a component of our own economic system, would commend themselves to other nations as well. But if America's antitrust policies could not win their own way in the international marketplace for such ideas, Congress, we must assume, would not have tried to impose them in an act of legal imperialism through legislative fiat. So the Supreme Court has clearly gotten the point that in cases of conflict, other countries actively resent our exportation of domestic norms through the vehicle of class action litigation. At one level, this is a very positive development, that the court recognizes and acts upon this international reaction. Yet retreating in the name of comity and cooperation to a system in which each nation looks only at what happens within its own borders may in the end undermine effective global regulation. It is clear today that even our own domestic interest extends beyond transactions that take place in our own markets. In the case of conduct that affects multiple jurisdictions simultaneously, such as global price fixing, the fact that other countries do not regulate their markets effectively means that even if we do, right, imposing fines or extracting damages awards as a result of transactions in our markets, the actors may still realize net gain from their conduct. And if that's the case, then such activity will continue, imposing ongoing private enforcement costs within the United States. So even the U.S. domestic interest includes, an interest in adequate levels of deterrence globally. In addition, beyond our domestic interest, we surely have shared concerns with other countries regarding the need for effective global regulation. Consider, for example, the very common situation in which an act of fraud affects both a group of U.S. investors who transacted here and a group of foreign investors who transacted overseas. There may be efficiencies to be gained by centralizing legal proceedings rather than engaging in duplicative litigation in multiple jurisdictions. In other words, our national regulatory interests coincide with and overlap with the interests of other nations, in addition sometimes to conflicting with them. The hard work to be done in addressing cross-border conduct requires engagement with those messy relationships. And if an attitude of antagonism toward our system causes our courts simply to disengage completely from that work, that's problematic. Finally, I return to the most important point, the point from which I started. We are in a phase of developing global regulatory strategies, as it is clear that global economic misconduct cannot be adequately regulated by a patchwork of individual national legal systems. So in addition to what is happening within the European systems or within the US system, we have the broader task of establishing and refining multilateral regulatory initiatives, whether in the form of harmonized substantive rules or cooperative public enforcement strategies. That work can be successful only if it builds on the foundation of a thorough and contextual understanding of the very different legal, procedural, and cultural norms observed in different countries. An attitude of antagonism that simply rejects other legal systems interferes with the development of that understanding. It fosters reliance on anecdotal information, on the big cases, the dramatic examples, and the worst case scenarios, rather than on empirical reality. Talking about this issue in Germany, everyone can talk about the McDonald's case, right? The hot coffee case. Talking about the details of the procedural norms that we actually use here is harder. So the issue here is not just the narrow instrumental one. In other words, as a country considers class actions, what can it learn from a more established legal system? It's the much broader question about how to establish the conditions under which effective regulation of global business can be achieved. The manner in which countries address the hard issues, the ones where there is real conflict among legal systems, has consequences not just for the resolution of those specific issues, but for the culture of global regulation generally. Today, when other countries are interested in something at least resembling U.S. class actions, there is this moment of possibility where we might take a hard issue and use it to improve the level of understanding and cooperation regarding private enforcement generally. Doing that will involve examining not just the procedural device of aggregate litigation, but the political economy of regulating through aggregate litigation. It will involve analyzing the embeddedness of class actions in the larger regulatory framework of individual nations today, as well as the way in which class actions might interact with the public regulatory structures developing at the international level. That is an important project, but it will be done effectively only when we set aside patterns of conflict and antagonism and focus instead on the shared imperative of improving cross-border regulation. Thank you.
We will be going upstairs for reception, and you are all invited to that. And if you have questions for Professor Buxbaum, I know she would be happy to answer them.
Thanks.
There. Thank you so much.
Thank you.